All right, welcome back. 23 minutes before the top of the hour. All right, this morning we talk about racism in the workplace. Send us your tweets about what you think constitutes racism in the workplace. In most metropolitan areas in South Africa, people of various races, creeds, socio-economic backgrounds, they work together, often not understanding one another and their circumstances. To tell us more about this, we are joined in our Cape Town studios by Jose Jorge, who is a director in employment practice at Cliffe, Dekker, Hofmeyr. As I mentioned, he's in our Sea Point studios. Good to have you. Thanks very much, Jose, for being our guest on Morning Live.
Thank you, Leanne, and good morning to your listeners.
All right.
Sorry, your viewers.
Listeners and viewers, I suppose we're pretty much so there. You made mention of a struggle song that was sung during a strike at a company. Talk to us a little bit more about this as a way of opening the conversation.
Leanne, the matter you're referring to has just recently come up in the Constitutional Court. It involved Duncan Meck, a company in the construction business, and a strike in 2013 at their Germiston site. So what happened is it was an unprotected strike, and during the strike, 9 of the workers sang a song, and the words roughly translated as something to the effect of, "Sing it from the rooftops, my mother rejoices when we hit the Boer." So what happened after the strike is that there were 2 allegations brought against these workers. The first was participation in an unprotected strike, and the second one was for singing racially offensive songs and for not complying with an ultimatum which was issued to the workers to come back to work. They were found guilty of both allegations. They were issued with a final written warning for the first, and they were dismissed for the second one. The workers, through the union NUMSA, then referred a dispute to the bargaining council, and this is where the controversy arises. So the arbitrator listened to the facts, and what she decided is that they were guilty of singing a racially offensive song. Mm-hmm. However, she drew a distinction between those words and the utterance of a completely racist, crude term. And what she also looked at, which is very pertinent here, is the context in which the song was sung. It is a struggle song, and she recognized that struggle songs are often sung in the context of a strike.
Yeah, yeah.
This is a peaceful strike. It didn't last very long, and no one was threatened within the strike. So what she found was that dismissal wasn't an appropriate sanction in this context. She issued them with a final written warning, and to show her displeasure at the nature of the song and the inappropriateness of the song, she only awarded them compensation of 3 months. So normally with reinstatement, you get full back pay, and this matter was heard, I think, in May the following year, so in May 2014.
Okay.
What then happened is that the company tried to review the award because they were dissatisfied with it, and the reason for their dissatisfaction is that they said any form of racism in the workplace is completely unwarranted and it warrants a dismissal. They also said that this is a form of hate speech. The Labour Court considered the matter and declined to review the arbitration award. What then happened is Duncan Meck applied for leave to appeal. This was denied. Eventually they petitioned the Constitutional Court, which decided they'd hear the matter because there was a constitutional issue that arose out of this, and that's obviously dignity, racism, etc.
Okay.
What the Constitutional Court then did is considered 2 issues. The first one was the conduct racist? And then secondly, was the decision by the arbitrator unreasonable? And I think what a lot of the pundits in the media have got wrong is that the starting point for the Constitutional Court here was that all the parties accepted that the song was racially offensive. What the court then had to consider was the decision by the arbitrator a decision that a reasonable decision maker couldn't make. So the test in a review is different to an appeal. So it's not whether it's right or wrong. And all the court had to find was that there was a rational basis for that decision. And the court found that it was a rational decision.
Okay. And
also significantly, it found that dismissal doesn't necessarily automatically apply in a case of racism or racially or in this case, where a racist term was used, or it was used in that context.
Okay, so I think that gives a great background into it. I let you sort of contextualize the whole story for us, because this is I think a landmark ruling that has really changed the face of how racism in the workplace is actually handled. But let's, I suppose, maybe go back a step and have a look at now, after this, how do you actually define and what constitutes racism in the workplace?
Well, very simply put, racism is a form of discrimination or prejudice against somebody else because of their race. Significantly, in this Constitutional Court judgment, what the judge raised was a concern about the number of incidents of racism in the workplace that are actually coming through the legal system. There have been, possibly in the last 3 or 4 years, 4 cases based on racism that I'm aware of that have gone through to the Constitutional Court.
Yeah. Yeah, so this is something that I suppose somebody has a right, and, you know, in terms of the law, how is it dealt with? I mean, are people actually held accountable for this racism and reported racism in the workplace?
Absolutely, they should be. If we're talking about the workplace, the employer has an obligation to protect its employees from any form of discrimination. So employees are protected through the Employment Equity Act, and employers should have policies in place that deal with this kind of issue and what the sanction should be. Outside of the workplace, there are various acts in place, and the aggrieved person can certainly take his or her dispute to the equality courts or raise a complaint to the Human Rights Commission.
Yeah, but I mean, if for instance, I am a victim of racism at the workplace, and somebody doesn't like me purely on the basis of my skin or says something derogatory, what is the process that I should follow? How should it work? And I mean, I suppose this is giving advice to any person that finds themselves in a situation where they are a victim of racism.
Well, your starting point is it really shouldn't happen at all in the workplace, but unfortunately, it is quite prevalent. What you have to do as an employee is immediately raise the issue with your employer. Your employer then should take steps to investigate the matter, and if appropriate, a disciplinary inquiry should be held.
And that's pretty much an internal thing. But you know, say that doesn't help.
It's an internal process.
But a lot of people say that they go internally and it doesn't help, and that, you know, they are still victim to this. And in fact, it may find that the entire company has a way of thinking like that, and you're almost fighting against a legacy within a company. And we find that in many companies. What do you do then?
You can actually bring a claim against your employer there, because your employer has then not complied with the provisions of the Employment Equity Act. And the consequences can be quite severe for employers.
If we look at an issue where, particularly what happened at Sasol, and I bring this up in as example, the Sasol saga that happened earlier, I think it was last month, when white workers went on strike over a policy that only black workers will get certain shares. Is that legal or not? Discriminating on share schemes for workers? Because now we're entering into a very different category.
It's legal in the sense that it's a mutual interest dispute. So there's certainly nothing illegal about that. And I'm not too close to the detail, but from what I understand, the share incentive scheme that Sasol was offering was actually in terms of the Employment Equity Act, or in terms of its affirmative action measures. But certainly the Solidarity members are entitled to go on strike for something like that. It's a means for them to put pressure on their employer so that they can also enjoy those rights or benefits.
Just finally, any other court cases that you know of when racism at the work has been dealt with via third party or a court arbitration?
Sorry, can you just repeat the question?
Just any other example of, I mean, we've cited 2 examples already in the conversation that we've had, but do you have any other examples where racism has been dealt with via a third party or court arbitration?
Yes, there are a number of examples. The most reported examples are usually where somebody uses the K word. There's been a recent SAB judgment, the South African Breweries judgment, where they dismissed an employee for using the K word in terms of a third-party external contractor. There's been a case at SARS, also for the use of the K word. And I think a more recently reported judgment was actually not even a crude use of any racist terminology, but simply the use of the word swatman. This was used in the context of a black person parking his or her vehicle next to the vehicle of a white employee, who then burst into a boardroom meeting and complained about the SWAT-man parking his car next to him. But the context and the manner in which it was used was deemed to be derogatory, and the employee was fired. And that was found to be fair by the courts.
Sure. All right, Jose, let's leave it there for this morning. But I just think giving viewers just a slight glimpse into workplaces in South Africa and what the law is, and certainly what your rights are when it comes to racism at the workplace. But just reading again on the judgment as I wrap up this conversation, this was the Con Court basically urging that the scourge of racism at the workplace be dealt with in a very serious manner and very firmly, basically saying, Justice Chris Jafta was saying the increasing number of complaints of racism at the workplace which come before our courts is a matter of concern. And that is a huge worry, but let's see how this story goes forward, and now with this judgment, if things do change. So thanks very much to our guest, Jose Jorge, who is our director, or he is a director at the employment practice at Cliffe, Dekker, Hofmeyr, talking to us about racism in the workplace in our C Point studio. All right, let's take a break. We'll see you after this. Stay tuned.